Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say this. I've said it, but nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, though we are now 4 years post onset of COVID, I'm still seeing it rear its ugly head in terms of disabling medical conditions. COVID and its long COVID complications have been linked to not only certain conditions, but also have been linked to new conditions that I quite frankly had never heard of, such as POTS. Or mast cell syndrome. And so we are seeing not only COVID complications, but new types of disabling medical conditions. And I also think that the world of COVID has had implications for the better, if you will, in chronic fatigue disability claims. I think the attention to COVID is making people pay more attention to chronic fatigue and to see whether or not there's any kind of link between the two, which has helped, I think, research. We're going to talk about four things today. The infamous Dr. Scott Norris and how disability carriers like Unum deny legitimate COVID claims. We're going to talk about how you can use the Social Security Administration regulations on how to evaluate a chronic fatigue syndrome or COVID claim in your ERISA claim. 3, how research into the mechanism causing ME/CFS and long COVID can help you get the medical treatment your ERISA plan or policy requires. And 4, I'm going to tell you a story about how a federal court rules that the claims process with a policyholder who has fibromyalgia, multiple arthralgias, and small fiber neuropathy should not be a guessing game for a disabled policyholder whose policy had a non-verifiable impairment payment limitation of 24 months. You can see we've got a lot of interesting topics that are applicable and impact your entitlement to disability benefits. Let's take a break before we get started. Welcome back to Winning Isn't Easy. Let's talk about the infamous Dr. Scott Norris and how disability carriers like Unum deny legitimate COVID claims. Disability carriers like Unum and disability plans have many tools in their denial, claim, or termination toolbox. And in my view, there are a number of questionable practices in claims, but two of the most common tools that are used are requiring objective evidence to verify symptoms in medical conditions that are not susceptible to objective testing. Now, one of the most common tools in a disability policy or plan demanding objective evidence is to verify symptoms in medical conditions like migraines, chronic fatigue, fibromyalgia, and COVID claims that aren't always susceptible to objective testing, or where the claimant presents with normal test results. The second tool and objection I have is the use of biased medical peer review doctors to create reasons for claims denial. Now, the second most common tool involves the situation where the disability carrier plan will use a peer review physician who is biased and who is hired to provide a guaranteed result to the disability carrier. And Unum's been called on the carpet about this. In fact, they were the subject a number of years ago of a statewide uniform attorney general settlement regarding their claims practices, part of which involved using biased providers. And quite frankly, I'll tell you, they haven't learned their lesson and they still do it. So how do disability carriers or plans like Unum use these two questionable practices in ERISA disability claims? I'm going to tell you the story of Dr. Sarah Whitehouse, who was victimized by Unum. And this case is is called Whitehouse versus Unum. It's a case out of Minnesota. Dr. Whitehouse was a full-time addiction medicine specialist at a hospital in St. Paul. And during COVID, the hospital was a COVID-19 patient deployment center. And guess what? In March of 2020, she contracted COVID. Now, she did return to work shortly thereafter, but continued having difficulty with breathing and extreme fatigues. These are the complications I see all of the time in COVID cases. Dr. Whitehouse left work a second time and then was diagnosed by Mayo as meeting the criteria for chronic fatigue syndrome and central sensitization disorder. She did improve and was able to return to work on a part-time basis. And subsequently, to her credit, she was able to go back to work full-time in 2022. Now, Dr. Whitehouse submitted claims for both short and long-term disability benefits under her employer's disability benefit plan, which was insured by Unum. Unum approved her short-term claim, but only approved partial benefits for the payment of her long-term disability benefits. How did they go about doing that? Well, they used the infamous Dr. Scott Norris and his controversial method of reviewing medical records. Unfortunately, disability carriers use doctors like Dr. Norris to create reasons to justify a claims denial. Dr. Norris is well known in the ERISA disability world for his questionable practices in reviewing medical records and rendering opinions in favor of disability carriers. You can use Google Scholar and find all of the reported cases involving Dr. Norris, so you don't have to take my word for it. When Dr. Whitehouse sued Unum, the court called Dr. Norris's credibility into issue because the court had noted that he had accepted in other cases subjective symptom reports when they favored Unum and rejected subjective symptoms when they favored the claimant. This is his typical MO. Again, please Google him in Google Scholar. You can even do a PACER search. The court also took Norris to task for failing to analyze Whitehouse's symptoms collectively, focusing too strictly on a lack of specific work restrictions and dismissing certain records as not being time relevant. The court noted that this approach was hardly a full and credible evaluation of Whitehouse's claim. Further, Norris inappropriately faulted Dr. Whitehouse for failing to provide objective evidence to verify the symptoms that Unum defines as unverifiable. They relied on her history of normal test results, which is common. Now, Whitehouse was diagnosed with a condition that accounts with individuals with normal test history. It's not uncommon for people to have COVID who have had, in the beginning, normal COVID test results or false positives. So the court looks at Dr. Whitehouse's medical records independently, and they determined that the records supported Whitehouse's claim that she suffered from chronic pain and severe fatigue throughout the disability period. Again, common complaints that one sees in these cases. The judge concluded that her symptoms were consistently documented. Her physicians agreed she had restrictions, limitations. She complied with all of the prescribed treatment, including pain management, that ultimately allowed her to return to work. The judge fortunately saw through Dr. Norris and awarded benefits. But this is the common game that carriers play, and you should be aware of this, particularly in these type of cases, be they migraine, COVID, long COVID, POTS cases, MECF cases, fibromyalgia cases. It's the game they play, and every carrier plays this game. Let's take a break.
You've been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.